a purely competitive market, isa yung trade union sa mga imperfection. So ngayon, i-discuss natin ano ba yung trade union, ano yung effect niya sa isang purely competitive market as well as sa isang monopsony. Positive ba yung effect niya? Negative ba yung effect? But before that, we'll go to the legal provisions concerning trade unions at i-differentiate natin yung term na trade union sa economics at kung ano man yung trade union in the legal concept. Kasi ang trade union sa econ pertains to the bargaining unit. Na yung bargaining unit is that is our concept of trade union, the bargaining unit. Kasi iba pa talaga yung um, tinatawag natin or term na trade union when it comes to law. Okay? So, let me just share my screen, pero siguro magpalit na lang ako ng device. Okay, for a while lang ha. Class, can you hear me?
Yes, ma'am.
Okay. So, class, I gave you a short notes about trade unions. And kung binasa ninyo yun, you will do well sa recitation kanina. Okay? So the purpose of that recitation is to know whether binasa nyo yung binigay ko sa inyong notes or hindi. So most of you got, let's say, 15 and above, 10 to 15 and above, which is good kasi ibig sabihin lang nun nabasa yung note na ibinigay ko sa inyo. So, ibibigay ko na lang sa inyo yung score after our class. Isabay ko doon sa bibigay ko sa 4-3. Okay? So, again, class, the concept of trade unions in economics is different from the concept of trade unions sa law. Okay? But, itatama na lang natin or gagamitin na lang din yung term na gagamit dito sa Philippines when it comes to trade unions, legal lib legitimate labor organizations, the bargaining unit, etc. Okay? So, the concept of trade union can be found dun sa second book ng labor code. So class, may actually tatlong libro yan. Pero bibilang natin yung, pero ang makikita lang talaga sa labor code ay dalawa. So, meron tayong dalawang libro sa labor code. The first one is labor standard and the other one, the labor relations. Pag sinabi natin class na labor standards, it talks about the minimum standard of employment. So, for example, yung minimum terms and conditions of employment or entitled niya or obliged siyang ibigay sa kanyang employees. That is labor standards. On the other hand, we have what we call as labor relations. Pag sinabi nating labor relation, it denotes all aspect of employer-employee relationship, which involve concerted action on the part of the workers. It usually associated with all the ramifications of unionism, collective bargaining and negotiations, and concerted activities such as strike, picket, mass leave, etc. So, kung ang pag-uusapan natin ay right to self-organization o yung karapatan nyo na mag-conduct ng strike, yung mga activities na yan is under ng tinatawag nating labor relation, which can be found sa Book 5 ng ating labor code. Okay? And yung labor relations is founded under the constitutional right ng isang individual. So, it is specifically found on Section 9 that all workers are guaranteed, among others, the right to self-organization, peaceful concerted activities, including to strike in accordance with the law, and to participate in policy decision-making processes affecting rights and benefits may be provided by law. Yes, to emphasize that yung right to strike natin should always be in accordance with the law. So we must follow the procedure provided by the law. Kasi class, alam nyo ba, sa ibang bansa, ang pag-conduct ng is illegal. Unlike here in the Philippines, it's permitted or it is allowed, but you have to follow a certain
Ma'am, excuse me.
Otherwise, magiging illegal. Oh, yes?
Ma'am, nagpuputol-putol po kayo. Yung audio niyo po.
Ay, nagputol-putol pa? Nagpuputol-putol pa, class?
Medyo kanina po, ma'am. Nagpuputol-putol po kayo. Pag nagsasalita po kayo, ma'am.
Pero ngayon, okay na?
So far po yan, okay, ma'am. Okay po.
Okay, sige. Again, class. Okay? So, sa ibang bansa, wala silang right to strike. So, illegal ang pag-conduct ng strike sa foreign countries. So, dito sa Philippines, is allowed as long as follow the procedures provided under the law. Okay? And then, we have this right, the right to participate in policy decision-making process. Okay? But that class, ang pag-intervene ni employee sa decision-making process ni employer ay patungkol lamang sa mga decision-making process ni employer pagdating sa kanilang right. O yung mga decisions ni employer na makakaapekto sa kanilang wages, sa hours of work nila. So, doon lang pwede mag-invest si employee. Pero kung yung mga purely managerial decisions, hindi pwedeng mag-intervene ang isang empleyado at i-raise itong karapatan na ito. Okay? So, I hope that is clear. So, let's expound the concept of right to self-organization. When we say right to self-organization, is the right of the worker and employees to form, join, or assist unions, organizations, or associations for the purpose of collective bargaining and or for mutual aid and protection, including to participate in the policy decision-making process affecting their rights and benefits. So tatandaan, class, you have the right to form or join associations or unions. Okay? That is mandated under the law. Ano ang purpose? For the purpose of collective bargaining. So we'll discuss mamaya ano ba yung collective bargaining. At the same time, for the purpose of mutual aid and protection. Okay? And itong on the Philippine etc. This is reiteration of the definition to rule
Ma'am, excuse po. Putol-putol po ulit yung audio niyo.
okay, class. Yung okay. Share ulit natin yung screen. Pero, no.
Ma'am, naglalag pa rin po sa end ko. And wala po yung share screen. Ayan po pala.
Mm.
Pero naglalag po.
Naglalag pa rin siya.
Yes po.
Ano nga to? Inayos ko na yung internet connection ko eh. Pero hindi pa rin siya.
Ayan po.
Okay?
Ayan po ma'am, medyo okay na po now. Tapos kita na rin po yung screen niyo sa end ko ngayon.
Sige. Baka na-restart ko kasi internet connection eh. Yung router. Kung okay na siya. Na tayo mag-start ulit. Kaya tayo ulit mag-start.
Yes po.
Okay. So, the right to self-organization is a fundamental right guaranteed by the Philippine Constitution and the Labor Code. So, this is just a reiteration of the definition of our right to self-organization as decided by the Supreme Court in the case of UST Faculty Union versus Bitonio. Okay? Tatandaan class, ang right to self-organization is a fundamental right under the Article 3 Bill of Rights. Okay? Bill of Rights natin, specifically the Section 8, sinasabi doon that the right of the people, including those employed in the public and private sectors, to form unions, associations, societies, for the purpose not contrary to the law shall not be abridged. So, ibig sabihin, class, kung kayo man ay private employee, kahit kayo ay public employee or government employee, you have the right to self-organization. So, private or employee, you have the right to self-organization, but you have to remember employee, medyo restricted yung pag-exercise ng ganitong right. So, tulad ko, isa akong empleyado ng gobyerno, empleyado ako ng PUP. So, pwede ako umali sa isang union. Part ako ng union. Okay? Yung union ng mga guro sa PUP. Okay? So, yung tinatawag na UGPUP. That is an example of union. Okay? Or an exercise of a right to self-organization in the government. Okay? And always remember, it shall be unlawful to any person to restrain, coerce, or discriminate against or unduly interfere with the employee's right to exercise the right to self-organization. Okay? So, notion sa right of organization. The first one is freedom or liberty to have not to be restrained by the employer sa pag-exercise ng isang employee ng right niya to self-organization. And yung pangalawa is the power of the employee not to join or to join from any association. Okay? So kasi class, ang right to self-organization may dalawang aspect yan. The right to join and right not to join. So hindi ka pwedeng pilitin ng isang employer or ng isang union na sumali or sumapi sa kanila kung hindi mo gusto or kung may valid reason ka. Kung let's say isa kang religious objector. Okay? So you cannot be compelled to join unions. Isang example na lang nito yung actually hindi to labor case ha. Case lang to. Wherein yung isang lot owner, kinocompel siya ng kanilang village, homeowners association, kanilang village, na magbayad ng kanilang association dues at membership fee. Okay? Biruin nyo yun class, yun lang yung topic doon or yun lang yung case doon, nakaabot pa yun sa Supreme Court. And sinabi ng Supreme Court, hindi mo pwedeng i-compel ang isang tao to join. Kahit na meron tayong, merong nakalagay sa Article 3 Bill of Rights na you have the right to self-organization. Kasi ang right to self-organization, dalawa yan. The right to join and the right not to join. So therefore, you cannot be compelled to join to any organization kung hindi mo gusto. And most specifically, if you have a valid reason. Okay? So that is the right to self-organization. Class, itong aspect na to, mababasa nyo to dun sa binigay ko sa inyong case, the Samahan ng Manggagawa sa Shipyard, sa Hanjin Shipyard versus the Bureau of Labor Relations. Okay? So, who may exercise the right to self-organization? So, I've already mentioned kanina that there are employees who have the right or who may exercise their right, at meron namang mga employees na restricted sa pag-form, join, or assist sa mga labor organization. So let's start first with the individuals who may exercise their right. So first one is all employees. Okay, then the government employees of corporations created under the corporation code. Di ba parang contradicting? Yung corporation dito, it only means that we have, let's say, GOCCs or the government-owned and controlled corporations. Still, they are under the government. Minsan, ang GOCC is created for propriety function. Okay? And simply under the GOCC under corporation code, you may exercise the right to self-organization. Ano ba yung corporation code? Ang corporation code ay isang batas kung saan doon simula ang buhay ng isang korporasyon. Ngayon, ang corporation code is strictly for the private companies. Unlike dati na ang mga GOCCs pwede silang i-create under the corporation code. Pero ngayon kasi, ang mga GOCCs ay kine-create na under a separate charter, under a separate law. Okay? So, if na-employ ka sa isang GOCC na create ng corporation code, you exercise the right to self-organization. Then, we have the supervisory employees. Ang supervisory employees class is different managerial employees. Okay? Si supervisory employees, ina-assist niya si manager. Si manager, ina-assist niya si owner. Okay? So, therefore, according to jurisprudence, si supervisory employees pwede siyang mag-form ng union, pero si managerial employees hindi. Kasi si supervisory employees na mas mababa kasi si managerial employees na mas mataas kumpara kay managerial employees, kay supervisory employees, is confidential yung kanyang position, unlike supervisory employees. So therefore, class, ang mga individuals under or mga workers under a firm na pwedeng mag-form ng unions, una, yung mga rank and file employees. Sabihin natin sa isang firm, nandun yung mga economists, nandun yung mga data encoder, nandun yung mga market researcher, they are considered as, let's say, rank and file employee. And then, pwede silang mag-create ng sarili nilang union. Pwede bang sumali si team leader? Assume natin that team leader is a supervisory employee? Hindi. So, therefore, ang gagawin ni team leader, mag-create sila ng sarili nilang union kasama yung iba pang mga supervisory employee. Okay? Pero tatandaan, si managerial employee, hindi siya pwedeng mag-form ng union at sumali sa union. Then, aliens with valid working permit. Okay? Yung mga aliens daw pwedeng mag-form ng union as long as you have a valid working permit here in the Philippines. Then, you have the security personnel o yung tinatawag nating mga security guard. Class, actually, before the EO 119, yung EO 119, yun ay pinirmahan ni President Corazon Aquino. Nung wala pang EO 119, okay? Hindi pwedeng mag-form ng unions ang mga security guard. Okay? And so therefore, kung meron silang mga working conditions na gustong i-levy sa government or i-levy sa kanilang mga firms, hindi siya mapapakinggan. But then, yun nga, EO 119 was signed by President Corazon Aquino. This lift the limitations when it comes to the right of the security guards to self-organization. And nasolidify yan nung in-enact ng Congress yung RA 6715, wherein totally tinanggal yung limitation na ito on the part of the security guards. So therefore, ngayon, pwede na silang mag-join sa labor organization, pwede na silang mag-join sa labor organization ng mga rank and file employees, pwede rin sa mga supervisory employees, depende sa kung ano ang kanilang posisyon. Kung ang posisyon nila ay considered as supervisory employee, sa union ng mga supervisory employee siya dapat sumali. Okay? Then, who are the employees who are restricted to join? So, una nga is managerial employees due to the nature of their work. Kasi, ang mga ang managerial employees ay nag-a-assist sa work, sa employer when it comes to the decision making, at when it comes to the disciplining their employees, hiring their employees. So therefore, si manager is more of the alter ego of your owner. So parang kung magke-create ka ng union, maaaring magamit ni manager yung mga nalaman niya dun sa firm para mag-levy ng kanyang mga benefits. Okay? Yung mga confidential employees, yung mga may hawak ng books and accounts, hindi rin sila pwedeng mag-form ng unions kasi may confidential information silang nalalaman dun sa firm. Then, employee members of a cooperative, the government employees who are not part of the corporations created under the Corporation Code, the employees of the international organization, foreign workers, the religious objectors. Okay, class, ito ay isa sa mga tanong kanina. Okay? Pwede ba nating i-compel si INC member na mag-join sa isang labor organization? The answer is no. Okay? No ang sagot dyan. So according to a jurisprudence, Victoriano versus Elizalde Ropes Workers Union, ang mga members of sex cannot compelled or coerced to join labor unions even if merong closed shop agreement. Ano ba class yung tinatawag nating closed shop agreement? Pag closed shop agreement, ibig sabihin lamang nito, ang isang employer dapat nag-hire lang siya ng empleyado mula sa members ng isang union. Okay? So for example, yung isang union may pool sila ng mga workers. So kung may closed shop agreement si employer at saka yung labor union, kailangan si employer mag-hire lang siya dun sa labor union na yon. Okay? That is closed shop agreement. Actually, class, ang closed shop agreement is legal sa ibang bansa. But here in the Philippines, as long as it is regulated, it is valid. And it can be found in your collective bargaining agreement as long as nagkasundo yung dalawang parties. Okay? Again, class, ma-check nyo na agad yan sa inyong recitation. So, hindi pwedeng i-compel ang isang religious objector na mag-join sa isang labor union. So, napanood nyo na ba yung palabas ni Andrew Garfield? Yung tungkol sa isang religious objector? Yes or no?
No.
Okay. So, try nyo panoorin yon. Although it is not about labor issues, pero tungkol din kasi yun sa religious objector. Si Andrew Garfield is isang Protestant ata or Mormon. And then, ang setting is World War. May World War noon. And during World War, compelled yung mga lalaki na mag-join sa military. So, or magbigay ng military service. Isa siyang Protestant or Mormon and pinagbabawal sa kanila yung paghawak ng armas. Pero wala siyang choice kasi war noon. So, nag-join pa rin siya sa sa military, pero isa siyang sundalo pero hindi siya umawak ng armas. Okay? Despite the fact na hindi siya umawak ng armas, naging bayani siya. Okay? Na bigyan siya ng Medal of Valor, ganon. So, panoorin nyo kung interesado kayo dun sa concept of religious objector. Okay? Then we have the AFP, police officers, policemen, firemen, and jail guard. Restricted din yung kanilang right to form, join, or assist labor organizations kasi syempre, yung nature ng work nila is for peace and security, just like your security guard. Okay? Na ano lang dito, na leaf lang dito. Kasi kapag nag-form sila ng union, okay? And itong union na to, hindi na bigay yung benefits, mas malaki yung probability or risk na magkaroon ng, let's say, coup d'etat. Okay? Kaya restricted ang kanilang right. Okay. This one, the right to participate in policy and decision-making process. I've already mentioned na kailangan balance yan with the management prerogative. Diba? Na-discuss na natin yung concept ng management prerogative or yung right ng isang employer na mag-decide sa pagdating sa management nila at the same time disciplining their employees. Okay? So as long as hindi yung decision-making process ni employer, hindi siya nakaka-apekto or nakaka-influence doon sa right ng isang employees, hindi pwedeng mag-intervene si employee at erase ang kanyang right to participate in policy and decision-making process. Tatandaan, itong right na to, pwede lang nating erase if there is deprivation of employees' means of livelihood, which is a property right. Okay? Kung business operation per se lang yan, hindi pwedeng mag-intervene. Okay? That is the right to participate in policy and decision-making process. Okay. Dito tayo. Linawin natin, ano ba yung concept ng trade union under the law? At ano ba yung national union or federation? So, ang national union or federation is with at least 10 locals or chapters or independent unions, each of which must be duly recognized collective bargaining agent. So, they can directly create local chapters. On the other hand, when we say trade unions, it is composed of group of registered national unions or federations and cannot directly create a local chapter. So, class, yung trade union, yan yung pinaka nasa tuktok. Okay? And then, yung trade union na yan, it is composed of national unions. At yung national unions na yan is composed of local chapters or let's say independent unions. Yung independent unions na yan, pwedeng yan yung mga bargaining unit. Pwede rin sila yung mga labor or legitimate labor organization. So ano lang gusto kong ipunto dito? So class, sa concept ng law, ang trade unions, siya yung pinakamalaki. Okay? Siya yung pinakamataas sa hierarchy. Pero mamaya, ang discussion natin sa trade union only talks about the bargaining unit in a firm. Okay? So para ma-differentiate lang natin yung discussion mamaya. Okay? So class, when we say bargaining unit, it refers to a group of employees sharing mutual interest within a given employer unit comprised of all or less than the entire body of employees in employer unit or any specific occupational or geographical grouping within such employer unit. Okay? Nasusundan, class? Okay. So, let's have these definitions. Okay? I've already gave you these definitions. So, labor organization is actually, class, the generic term. Okay? Yan yung generic term ng lahat ng organizations na nababanggit natin sa labor code. Okay? As well as different organization na nag-exist para sa labor. Okay? Para i-promote natin ang labor. Okay? So labor organization means any union or association of employees which exist in whole or in part for the purpose of collective bargaining or dealing with employers concerning terms and conditions of employment. So it is again created for mutual aid, interest, cooperation, protection, and other lawful purpose. Okay. Ano naman yung legitimate labor organization? A legitimate labor organization is a labor organization duly registered under DOLE and includes any branch or local thereof. So class, mahalaga na yung tinatawag nating union sa isang organization or sa isang firm na naka-register sa DOLE. Okay? Kasi kapag naka-register ka sa DOLE, meron kang mga karapatan. Okay? At the same time, pwede kang ma-elect as the collective bargaining representative. Kasi class, imagine natin, ito yung firm. May legitimate, may labor organization. May isa ulit labor organization. Itong si number 1 labor organization, nagpa-register. So, legitimate labor organization siya. Ito na hindi nagpa-register kay DOLE. So, labor organization lang siya. Okay? So, si legitimate labor organization, pwede siya tumao sa certification election. Pag sinabi natin certification election, siya lang yung, ito yung election kung saan i-identify natin sino si collective bargaining agent. Pag sabi natin collective bargaining agent, siya yung agent ng mga empleyado. Isa siyang grupa na nagre-represent sa mga empleyado para i-levy yung mga benefits nila. Okay? So kung hindi ka registered, hindi ka pwedeng tumakbo dyan. At kung hindi ka makakatakbo, hindi mo ma-levy kung ano man yung gusto ng mga miyembro mo. Okay? So, ganun siya, class. Okay? Ilang minuto na lang?
$15 po.
Okay. Meron din situation, class, we're in. May isang LLO. O, assume na natin, LLO or yung legitimate labor organization, registered na siya sa DOLE. Isa lang siya. At sila yung naging collective bargaining agent natin. Si LLO, ililevy niya yung mga right ng kanyang mga kanyang mga members dun sa employer. Kapag nagkasundo, okay, magbe-benefit itong mga members ng LLO. Pero merong mga non-members. Sabihin natin si religious objector. Si religious objector, nakakatanggap pa rin siya ng benefit. Okay? Kaya lang, hindi siya member nung LLO. Eh, di ba ang mga members ng LLO, magbabayad sila ng dues at membership para mag-part ng LLO na yun. Eh, tamang mga non-members, tumatanggap na ng benefits, hindi pa bayad na membership and asset dues. So, in this case, parang nagkakaroon ng unfair treatment. Nagkakaroon ng discrimination. So, according to the law and jurisprudence, kapag ikaw ay non-member at tumatanggap ka ng benefit na nilevy mula sa collective bargaining agreement ng collective bargaining agent na mula dun sa LLO na meron sa inyong firm, kailangang magbayad ka ng agency fee. Yung agency fee na yun yung kabayaran kasi sa kung ano man yung naging benefit mo sa ginawa ng collective as collective so, kasi hindi ka miyembro, kailangan in return magbigay ka sa kanila ng fee.
Okay? For the benefits na nakukuha mo. Okay? So, hindi rin pwedeng i-discriminate ang mga non-members sa benefits na nakukuha ng mga member ng isang union. Okay? So, class, pag binabanggit ko yung union at saka yung LLO or collective bargaining agent, i-assume na lang natin na iisa sila. So, reality magkakaiba talaga. Okay? Hindi naman tayo masyado magiging strict sa ganyang sa definition. Okay, then we have the bargaining representative, a legitimate labor organization or any officer or agent such as organization, whether or not employed. Then we have the organization information, function, administration has been assisted by under the labor practice, unfair labor practice by the labor. Hindi na di-discuss kung unfair labor practice. So, nait yung karapatan nyo, vinolate yung karapatan nyo when it comes to, say, overtime pay. Okay? Pag sinabi natin ULP class, it does not refer to your labor standards. Pero ang unfair labor practice, it refers to the violation on the right to self-organization. For example, yung employee, gusto mong sumali sa union sa inyong kanya. Pero sinabi sa inyo ni employer, kapag sumali kayo sa union, dyan sa company na yan, tatanggalin ko kayo. That is an example of unfair labor practice because the employer intervenes to your right to self-organization. And that is a violation under the labor code. Another one, gusto nyong magbuo ng union sa inyong company. Okay? Pero, itong si employer, sinabi na yung mga officers na mai-elect dyan sa union na yan ay tatanggalin ko. So that is an example of unfair labor practice. Okay? Most specifically, ang tawag dyan, union busting. Kasi nag-i-intervene tayo sa right to self-organization ng ating mga empleyado. So tatandaan class that is unfair labor practice. Narinig kasi natin minsan yan sa mga balita, tapos ang akala natin, unfair labor practice is about violation do sa mga working conditions ninyo. Okay? So, nandito kanina, kapag kayo ay registered sa DOLE, you are considered a legitimate labor organization, magkakaroon kayo ng rights. Ano yun? Right of representation, just like what I mentioned kanina, kaya nyong tumakbo certification election para mag-elect bargaining agent ng inyong ng workers. Okay? At the same time, you have the exclusive right to collectively bargain. Okay? Then, you have the right to information. Kung ikaw ay legitimate labor organization, mabibigyan ka ng mga informations when it comes to annual audited financial statements, balance sheets, profit and loss statement. So, bakit kailangan natin ng ganitong mga information? O bakit kailangan i-furnish tayo ni employer ng mga ganitong documents? Para makita natin whether nagkakaroon ng loss, nagkakaroon ng profit. Kasi pag nagkakaroon ng profit class, pwede nating i-raise yung tinatawag nating profit sharing. Na kapag malaki yung profit ng company or ng firm, pwedeng yung chunk or a portion ng profit na yon maibigay or ma-divide, okay, dun sa ating mga empleyado. Okay? And we also have the property rights, the right to own property, real and personal properties, the right to sue and be sued. As you may notice, dun sa mga binibigay kong jurisprudence, you have these unions. Okay? So, ibig sabihin, you can sue and be sued. Then, to undertake all other activities designed to benefit the organization and its member, and to collect reasonable membership fees, union dues, assessment, fines, and contribution. Siyempre, para na rin sa continuous operation ng inyong union, kailangan nyo rin ng mga fees. Pwedeng mag-collect niyan. Okay? Nasusundan pa, class? Okay. So, aside from your right, okay, you also have, okay, duty to bargain collectively. Actually, kasi lang labor organization or legitimate labor organization ang may duty to bargain. May duty din to bargain yung employer. Okay? Kasi two-way yan, class. Kung may duty to bargain ng employer, dapat meron ng labor organization, kailangan nilang meet, kailangan nilang mag sa working conditions ng employers when it comes to business machineries, kapag nagkaroon ng problema, at maiwasan yung strike, blackout, etc. Okay? So the duty to bargain collectively means the performance of mutual obligation to meet and convene promptly and expeditiously in good faith for the purpose of, ito class yun, negotiating an agreement when it comes to the wages, hours of works, and all other terms and conditions of employment, including proposals for adjusting any grievances or questions, okay? The executing a contract incorporating such agreements if requested by either party, but such duty does not compel any party to agree to a proposal or to make any concession. And lastly, to negotiate over the terms of new contract and propose modifications when an existing agreement is validly open. Okay, class. Ang CBA, yung collective bargaining agreement natin, ang kanyang lifespan is 5 years lamang. So after ng 5 years, okay, pwede siya ulit i-retain or pwede ulit siyang baguhin. Okay? Depende sa kung ano yung sa tingin ng mga workers na kinakailangan nila. So, before the expiration ng CBA or yung collective bargaining agreement, meron tayong tinatawag na 60 days freedom period wherein kung same collective bargaining agent yung na-elect, okay, pwede na silang mag-usap ulit sa kung ano yung maaring maging agreement nila when it comes to the terms and conditions of employment, etc. Okay? So kapag hindi sila nag-reach dun sa agreement class, pwedeng magkaroon ng tinatawag nating bargaining deadlock. Yung bargaining deadlock, ibig sabihin lamang nun, hindi kayo nagkasundo when it comes to the CBA. At ang bargaining deadlock can be a ground for strike. Okay? Pwedeng magkaroon ng strike. Okay? Pero tandaan, meron pa ring effort to bargain. Okay, balik tayo dito, class. So, ano ba yung collective bargaining agreement? It refers to a contract executed upon request of either the employer or the exclusive bargaining representative of employees, incorporating the agreement reached after negotiations with respect to wages, hours of work, and all other terms and conditions of employment, including proposal for adjustments, any grievances or questions under such agreement. Okay, class. So, yung collective bargaining agreement, that is considered as the law between the contracting parties. Okay? And the, let's say, the employer and the collective bargaining representative. At ano ba yung nature ng isang CBA? So aside sa it is a law between the contracting parties, okay, wherein the compliance is mandated. Compliance between the employer as well as sa collective bargaining agent is mandated. Ang kanyang purpose is to business condition. So, kailangan meron tayong collective bargaining agreement para ma-select natin kung ano kailangan sa work, mas maging productive mga workers, as well as yung charge of working conditions nila maayos natin. So, at maging fair for both parties. Okay? So, that is for your CBA. And these are the mandatory provisions under the CBA. Wages and other types of compensation, yung work hour, holiday. I've already mentioned about the yung holidays natin and vacation, especially yung mga leaves natin, di ba? Yung SIL natin, yung ang mandated below, that is 5 days a year. And yung mga binibigay na additional vacation leave and sick leave, that is out of gratuity na lang ng inyong employer. Isa kasi ginagawa nila yon para ma-entice yung mga bagong empleyado na pumasok sa kanila. We also have bonus, the pension, and retirement plans, not retirement plans. Okay? Seniority, transfer, layoffs, employee workload, the work rules and regulations, the rent of company houses, as well as the union security. When it comes to grievance procedure, ito yung mention ko na kapag let's say nagkakaroon ng problema sa union or yung sa employer, pwedeng dumaan muna tayo sa grievance procedure. Hindi agad magkakasuhan. Mag-uusap muna tayo. At kung hindi pumayag yung usap natin, pwede tayong pumunta sa NCMB, National Conciliation and Mediation Board, okay? Para doon naman tayo mag-usap. Okay? Itatry ng NCMB or yung director nila doon na ipag-conciliate muna yung ating mga gusto. Okay? Or ang ating mga gustong ilagay dun sa CBA. Bago tayo magkasuhan. So actually, class, napakarami pang napakarami pang procedure na pagdadaanan bago tayo pumunta sa court. Okay? Yung court ng mga sa labor cases class is NLRC. Yan.
Ma'am, excuse me po, mag-end po yung call. Yung meet po.
Okay. Please create another call. Okay? Thank you. Okay, class. Let's discuss or let's continue our discussion. Konti na lang to. Okay. So, nakikita na? Nakikita na ba yung share ko, class? Ba't walang sumasagot sa BSE 44?
Yes po, ma'am.
Okay. So let's discuss the concept of trade union in economics. So isipin nyo na lang class itong trade union, yan yung collective bargaining agent or unit. Okay? So let's say we have this yearly competitive labor market. You have your downward sloping demand curve and upward sloping supply curve, which represents your employees. And you will notice that the intersection of the two will give you the equilibrium wage, the competitive wage in the market. However, kapag nagkakaroon tayo ng tinatawag nating collective bargaining unit at nag-intervene siya sa ating magle-levy sila ng higher wage. So you will notice wage is higher than the competitive wage, and because of this, okay, because of the increase in the wages, yung demand for employers or employees increases. Because higher wage or higher number of individual, higher wage means higher cost of production. Okay? So, costly on the part of the employers to hire more employees. So, that's why bumababa quantity demanded for the labor. At syempre, dahil higher yung wage sa market, or let's say, higher yung wage dun sa firm, mas marami yun ang gusto mag-supply ng kanilang labor. Okay? Mas marami ang willing to be employed in that firm. And because of that, nagkakaroon tinatawag nating surplus of labor. Or simply yung tinatawag unemployment. Kasi ginakayang i-hire ni employer yung mga natitira pa dun sa pool kapag masyadong mataas sa competitive wage or mas mataas sa competitive wage yung ating trade union wage. Okay? So therefore, anong pwede nating ma-infer? So check nyo lang to class the quantity of labor na pwedeng i-hire at kayang i-hire kapag competitive yung ating wage is at QL. Pero kapag meron ng intervention ng bargaining unit, bumababa na yung quantity. Okay, again, ano yung pwede nating ma-infer? Whenever we are in a purely competitive labor market, the intervention of trade unions or collective bargaining unit can increase the wage. However, it will affect the employment. Yung effect, karoon ng decrease sa employment. Okay? Nakukuha class? Okay. So, in this kind of situation, although makikita natin na maganda yung hangarin ni trade union na itaas yung wages at yung standards of yung working standards ng ating mga empleyado, nakaka-apekto siya sa capacity ni employer to hire more. Okay? So tatandaan that we need to consider two concepts sa intervention of trade union or collective bargaining unit sa isang purely competitive market. So first one, yung tinatawag nating union density. When you say union density, it talks about the number of the or the percentage of the profession sa isang union. Okay? Kasi kapag mas malaki yung inyong union density, mas malawak din yung inyong kapangyarihan. So the greater the union density is, the greater the union power. So kapag maraming professional dun sa isang union, syempre hindi mas madaling makipag-usap or mag-come up with an agreement with your employer. Yun yung tinatawag nating union density. At meron din tayong tinatawag na union markup wherein talks about the difference between the let's say the benefits that are it talks about the benefits being received the union members to those who are not union members. So tatandaan ang pagko-compare sa kanila kailangan nasa same profession. Hindi pwedeng isang economist at isang construction worker. Ano yung magiging difference kung union member ka or hindi? So, hindi natin makikita yung totoong difference. So, kailangan kung check natin yung difference ng kanilang benefits kapag union members sila, kailangan economist to economist, construction worker to construction worker. Again, class, we need to consider two things in intervention of trade unions or collective bargaining unit in a firm. First one is the union density, and the second one is the union markup. Okay? So, I've mentioned last time that kapag magkakandak tayo ng strike, it should always be in accordance with the law. Otherwise, it is considered as illegal. At kapag illegal yan, alam niyo ba, merong mga naki-criminally charge sa illegal strike. Okay? Hindi lang siya tungkol sa labor cases, ha. Pwede rin kayong magkaroon ng criminal case. Pero certain situations lamang yun. Okay, so these are the procedures. First one is yung effort to bargain, filing and service of notice of strike. Kailangan ipaalam nyo kay employer at sa gobyerno na mag-strike kayo. Observance of the cooling off period, yung 15 days for ULP, etc. Okay? So, hindi siya basta-basta, nalalabas lang kayo dun sa company ninyo at mag-strike kayo. Kailangan may period yan para mapag-usapan ang mga bagay-bagay. Okay? So, how about a situation where there is a trade union or collective bargaining unit sa isang monopsony? Di ba, class, na-discuss na natin yung monopsony, or a monopsony is the sole employer of a labor in a given profession. Natatandaan pa? Okay. So, dun sa monopsony, you will notice that the monopsony wage is lower than the competitive wage. Kasi ang monopsony, it has the capacity to set the wages. Okay? Isa yun sa part ng kanyang monopsony power. And because of that, mas mababa yung employment as well as yung wages ng ating mga worker. So, what if mag-intervene si trade union or yung collective bargaining unit? Ano kaya yung effect niya dun sa ating employment at sa ating wages? Okay? So, this is just a discussion na-discuss ko na rin last time regarding sa kung bakit yung ating supply is equal to the average cost of your wage. This is just an explanation and cancel out lang yan. Okay. So, tayo. So, previously, we discussed na mas mababa yung monopoly wage dun sa ating competitive wage because of the monopoly power. But whenever there is intervention ng trade union or yung collective bargaining unit at nag-limit sila for higher wage, you'll note that trade union wage is above monopoly wage less than the competitive wage. Kasi syempre, hindi rin naman papayag si company na level na ng competitive wage, yung wage na ibibigay niya sa mga workers. Okay? So, if we now still, mas mataas pa rin siya kung monopsony wage. Because of that, you will not the labor hired also says, okay? Improve so that the Q the so paano ma-infer? Whenever your collective in a monopoly, employment will increase as well as the wages. Okay, hope that is tayong mga gusto.
Ma'am?
Yes.
Nawala po.
Ang alin?
Nagsalita po ba kayo kanina? Parang nawala po kasi yung audio niyo saglit.
Hindi na ako nagsalita kanina.
Ay, okay po.
Tinanong ko lang, if you have questions, pwede niyong erase? Meron? Wala? So, wala kayong question, class?
Pwede po paulit yung sa graph kanina. Kasi medyo choppy po.
Sige. Ulitin natin yung sa graph. Saan dito? Dun sa intervention na ng monopsony? Intervention na ng trade union sa monopsony.
Yes.
Tama ba? Okay, balik tayo. So again, class, whenever there is intervention of trade union sa isang monopsony, mapapansin nyo that it is above the monopsony wage. Di ba, class? This is your competitive wage. Kung ang pinag-uusapan natin is purely competitive market. Pero dahil monopsony tayo, mababa yung ipapasweldo ni monopsony. Okay? Kasi nga, part yun ng kanyang monopsony power. Kapag nagkaroon ng intervention ng trade union or collective bargaining unit sa isang monopsony, syempre magle-levy sila ng higher wage. So this will be your trade union wage. At kapag nagkakaroon ng trade union wage, you will notice that this is above your monopsony wage, but less than your competitive wage. Kasi syempre, hindi naman papareho si employer equal na or kapareho na competitive wage yung ipapasweldo niya sa kanyang mga employees. So they need to meet halfway. Okay? And due to this, you will notice that employees that can be higher year na higher pa rin. Okay? Mas ang pwedeng employee ni employer dun sa ating mga kasi class, tandaan, hindi ko ba nabanggit, sa ganito siya shop agreement. Pag sinabi natin closed shop agreement, yung mga i-hire ni employer ay galing lang yun. Okay? So dito, willing mag-supply ng mas marami labor yun ng kanilang mga empleyado. At the same time, willing din si employer mag-high amount of employees. Kasi nga, part yun ng kanilang collective bargaining agreement. So, anong pwede nating ma-infer? Whenever there is an intervention of a trade union or collective bargaining unit in a monopsony, employment increases as well as wages. Okay? Nasusundan ba? Okay. May questions pa? Okay. So, class, ay at Miss Lumibaw.
Hello ma'am, question lang po. Since isa din po sa right ng mga legitimate CBs na to be sued and to sue, ayan. Question po ma'am, if ever nagkaroon po ng strike na sabi niyo po kasi kanina dapat ipaalam din sa employer, sa government, bago sila magkaroon ng strikes, ganyan, para ipalabas yung hinanaing nila. Ano po yung pwedeng kasuhan doon sa union? Like, buo ba sila? Or yung members lang po?
Okay. O, sige. Ang kakasuhan lang sa kanila is yung mga officers. Ang officers ang magiging liable.
As a general rule class, officers. Pero, pwede rin yung mga union members or empleyado kapag yung mga empleyado ay nag-engage sa, let's say, pisikalan. Okay? So, pwede rin sila. Okay? So, kaya as much as possible, kapag nag-i-strike, ipapaalam natin sa government kasi magkakaroon yan at saka sa dun sa firm para magkaroon ng at least man lang peaceful na strike. Okay? Hindi may iwasan yung mga pisikalan, magkakaroon ng sakitan, etc. Okay? Kasi ang target natin dito, ang goal natin dito, yes, kaya mong i-air yung redress or kaya mong i-air yung gusto mong iparating kay employer, but at the same time, it should be peaceful. Okay? Again, the officer ang mananagot, siya ang magiging liable, pero maaari ding managot or maging liable si employee or yung union member. Okay?
Thank you.
Oh, yes, Gerald, parang tumataas yung kamay mo kanina.
Pwede pong makahingi po ng presentation po ngayong araw.
Okay, sige.
Okay. Thank you po.
May questions pa? So, class, i-upload ko dito yung scores if you are willing. Willing ba kayong tingnan yung scores nyo or alam nyo na? By just discussing yung yung mga sagot. Again, class, yung recitation for today will be considered as part of your recitation at yung recitation na yon is about ilang percent ba madalas na binibigay ko? 10 to 15% of your grade. Okay? So, bawi tayo next time. Kung magkakandak pa tayo ng recitation, pero mukhang hindi na. Chinek ko lang kasi talaga kung nagbabasa kayo eh. Mukhang hindi nyo binasa. Okay, so wait lang class. Nasaan ba yung aking? Wala pala dito. Okay, wala pala dito nasa isang laptop ko yung PowerPoint presentation. Okay, so again class, if my concern, erase lang through precedent and itatap ko si President kung mag-meet tayo on a Friday or on a Saturday. Probably that will be our last meeting for this semester kasi I will try my best na pagsama-samahin na yung mga concepts ng inflation, unemployment, and labor legislation. Kasi hindi natin masasabi kung ano yung mga susunod na araw kung may mga activities pa kami. So, at least man lang makover ko yung mga dapat makover. Actually, matatapos na rin naman tayo. So, ano pa ba mga announcements? Wala naman na, no? Okay. So, I'll see you class sa susunod na week. And, yun lang. Okay? So, wala pala akong sasabihin. Sige, anin ko lang yung PowerPoint presentation and ibibigay ko yung, hindi ko ibibigay sa Meet. Ibibigay ko kay President yung result. Siya na lang ang magbigay sa inyo. Baka kasi may, pa kayo certain degree of privacy na ayaw nyong i-broadcast kay classmate yung inyong score. Okay? Kay President na lang. Tanong nyo na lang sa kanya. Okay? Goodbye, class.
Thank you po, ma'am.
Thank you po,
Bye-bye,
ma'am.
ma'am.
Po, ma'am.
Thank you, ma'am.
Thank you po.